In these times of cautious social interaction, TV Education Network provides an essential learning opportunity for us all. My name is Jack Cyngler, and as I've been introduced, the firm is Cyngler Kaye Levy Lawyers, and the emphasis, I suppose, is on leases, property law, and commercial agreements. I thought I'd start with an icebreaker, and something like this. Do you know how much a polar bear weighs? Enough to break the ice. So that sort of brings me to what we want to do at the moment. We want to avoid our clients falling into the ice. Drafting commercial contracts with precision. All three topics today have a similar theme. How do we reduce the risk to our client, be it indemnity, exclusion clause, avoiding drafting of unfair contracts, risk management. So I'd like to briefly introduce our speakers today, the three, by name at least. And so we've got Shah Rusiti. He's partner with Tees, Hodgson and Ward from Sydney. James Dapucci with Mackinson Dapucci Lawyers in Sydney, and coming into the studio later is Peter Seiss of Clayton Utz, Melbourne. Now, first session with Shah, we'll look at a number of issues, including the principles of Condelfo Constructions and State Rail, dealing with implied terms, advantages of indemnities, proper drafting of indemnities, guarantees and warranties, and all possible carve-outs with regards to warranties, e.g. by disclosure letters. Shah, as I say, is a partner at Tees, Hodgson Ward. He's been practicing for 30 years in business law and commercial law, information technology and commercial property. And he's widely recognised for his expertise in business structuring, including shareholder agreements, business acquisitions and sales. Shah's a member of the New South Wales Law Society Specialist Accreditation Committee and is a regular presenter at conferences on business and commercial law. Let's cross to Shah. Thank you. Thank you, Shah. I want to thank you for a very informative presentation. I'd also like to remind our participants of this online seminar to ask questions, and they can do so by tapping at the bottom of right of the screen. So if you've got any questions from the audience, let us, if there are any questions there, let us know. I think we have one question at the moment, and it's a simple question from Michael, who asks about case references, and I think all the case citations are referred to in the papers, so I think that answers that one pretty quickly. Another one from Michael is the name of the book by Cyngler, and I think it's, well, perhaps you can just tell us, Shah, again.
Oh, it is, it's just called Warranties and Indemnities. I think if you just search online for Cyngler Warranties and Indemnities, you'll have no problem finding it.
All right, that's excellent. And whilst we're waiting for some further questions, there's a scenario which, Shah, we've discussed, and maybe it's worth my while reading it out, and you can chime in when you think it's appropriate. I'll just read I'll read a particular clause and get you to comment on it by breaking it down. So the clause is, each party must, to the maximum extent permitted by law, release, indemnify and keep indemnified each other and its related bodies corporate, open bracket, as that term is defined in the Corporations Act 2001 Commonwealth, close bracket, and their respective directors, officers, employers and agents, bracket those indemnified, close brackets, from and against any demand, claim, action or proceeding made or brought by or against any of those indemnified, howsoever arising, and all losses, liabilities, costs, expenses or damages, open bracket, including investigative costs, court costs, legal fees, penalties, fines and interest, close bracket, arising directly or indirectly in connection with this agreement, except where the liability arises directly out of the negligence of either party or breach by either party of its obligations under this agreement. So that's quite a mouthful, Shah. I might get you to break that down for us a bit.
Sure. So just so that you know, I didn't make this up. This is a real clause from a real contract.
Okay.
And it's one that gives you a headache every time you try to read through it. But breaking this down, firstly, it says each party releases, indemnifies and must keep indemnified each other. Now, I assume that means the other party, and its related body corporates. The its presumably is the other parties' related body corporates and their respective directors, officers, employees and agents. So each party is indemnifying the other party, its related body corporates, their directors, officers and employees and agents. That's okay. But against what? Next bit. From and against any demand, claim, action or proceeding. From and against. What does that quite mean? Made or brought by or against any of those indemnified. So hang on. A claim that's made by an indemnified party, well, you'd only want that to apply to a claim that they can bring if their indemnity is actually triggered, not because they've got a right to make some claim. So there, you're getting ambiguity about what is it that you're indemnifying. So made or brought by or against any of those indemnified, howsoever arising. What does that mean? How do we know what the limitations of this are? And so this is in addition, if you like, to that indemnity, all losses, liabilities, costs, expenses or damage arising directly or indirectly in connection with this agreement. What does that mean, in connection with the agreement? So just looking at that word, the fact that they start, at the beginning, they start with each party releasing, indemnifying the other, and then go on to confuse it by saying by or against any of those indemnified. If I'm releasing you from an indemnity, how am I making a claim against you for the indemnity? It can't be a claim by me. I might be trying to pass on a third party's claim by saying, well, you have to indemnify me in relation to that third party claim. But that means that it is a claim made by a third party. So very weird drafting. And then the wonderful part about all of this, aside from it arising directly or indirectly in connection with the agreement, how's a court going to interpret the scope of that, what's indirectly in connection with an agreement? The exception at the end, where the liability arises directly, we're back to directly now, out of negligence of either party. Hang on, aren't I just getting an indemnity from you? Or shouldn't that be an indemnity in relation to your breach or your negligence only? But no, I'm getting an indemnity from you about my negligence as well, because it could be the negligence of either party. And then it gets worse. Breach by either party of its obligations under this agreement. What? You have to indemnify me because I breached the agreement. So I'm not trying to be, well, actually, I am trying to be particularly critical about whoever drafted that clause at the time. But I had to give that example because I have to confess it's probably one of the worst pieces of indemnity drafting I've seen. You only succeed with indemnities if your terminology is precise. So please, please, please draft your indemnities carefully and don't use that example.
Shah, thank you for that. I just wanted to, deals with the importance of being very specific and as you articulated in your early presentation. I've got a simpler one for you though. Guarantee, where a wife guarantees, say, a lease document in which her husband's company is a tenant. She knows nothing about the business, not involved in the business. Husband tells her, just sign here. She may or may not sign. We don't. He may. Who knows who signed it? The question is, I suppose, does this raise, similar to finance documents, some kind of Amadio defence, or what are your views about that?
I think with commercial contracts, there is a difference with the Amadio defence. I think if you've got a husband and wife and they're both, for example, shareholders and directors of the company, then the starting position is that as a director, she has an obligation to make herself informed, to participate in the decision-making process and do that. It's not enough to say she knew nothing about the company, because what you're looking at is how she's represented to an innocent third party. She's represented to a third party as a director and shareholder of the company. So in that context, unless there is some specific knowledge that the other party has, they would be entitled to rely on that guarantee. If you look at a lease in particular, if it had directors' guarantees and the wife signs off as a guarantor, why would the landlord have any obligation to ensure that she understood the terms of the obligations under the lease? That's quite different from, for example, consumer finance arrangements, which of course have much tighter obligations on the financier. In terms of general contract law, that scope's not necessarily there. So
Shah, if I may, what if the wife isn't a shareholder or director of the company, but for some reason the landlord or lessor has sought comfort of the wife signing as guarantor?
Well, then I think that opens up some scope for the wife. If she didn't understand the transaction, if the party seeking the guarantee made no attempt to confirm that she understood the transaction, or that in fact she'd received any advice on her potential liability, that could open some scope. It may be that because it's a guarantee, there's an opportunity for her to run a case based on either failure to provide information that was relevant to her decision or misrepresentation in the course of conduct by the party obtaining the guarantee. But this isn't a consumer loan. It's a commercial transaction, and it's not unusual for parties to be asked to guarantee a corporate entity. It is unusual to have someone who's not a director, not a shareholder, has no interest in the lessee company to be required to give a guarantee. So I think that's really the wedge into the defence of the case, that she wasn't a director or a company officer or shareholder, that they made no attempt on the lessor's part to make her aware that the fact that she might have relied on her husband telling her that it's okay to sign the lease wasn't enough.
Okay, well, thank you for that, Shah. Thank you for your excellent presentation again. It's been very informative, as I've said, and we're now going to take a short break, I believe, and so hope everyone's enjoyed that. I certainly have, and we'll see you all soon. Thanks very much.
Thanks.
Welcome back, everyone. I'm going to be introducing our next speaker shortly. James Dapuche, and James will be talking about drafting effective exclusion clauses, in commercial agreements. The paper will cover the importance of clarity in drafting exclusion clauses and not to rely on generalities, and in particular beware of reliance on the contra preferentum rule. Now, a little bit about James. He's a corporate and commercial litigator for private clients, acting for private clients, commercial entities and not-for-profits. His practice includes some work in the privacy and intellectual property space. He's a senior associate with Mackinson Dapache Lawyers in Sydney, and he's commenced a series of videos, including coffee and a case note. And there, James has the opportunity to briefly reflect on recent decisions over a piccolo latte, which James will tell us about later, sharing his knowledge with others in a way that is both approachable and rigorous. Over to you, James. Thank you, James. I saw no ambiguity there, so
Very kind, Jack.
Thanks for an excellent presentation, and I'd like to remind our audience that they've got an opportunity to ask questions. They just need to tap at the bottom right of the screen. So, but in anticipation of that, I might just ask a couple of questions or discuss with you. We'll put the piccolo latte aside, perhaps when I'm up in Sydney. Next,
Sounds good.
But with regard to the Santos case, what do you say the ambiguity was in the first contract, the big contract?
Yeah. Yes. No, this is. I'm glad you asked. It's amazing you thought to, Jack. This is the case that had our first big, long written contract and our short little all caps docket contract. And in short, what the court found was that ambiguity arose from that term in connection with the goods. And so it was not clear whether pallets, things that carried the goods, were things that were in connection with the goods. And so there were multiple meanings, because in connection with the goods might include pallets or it might not. And so the court worked through the mechanism and found that multiple meanings were available. And so because multiple meanings were available, the contra preferentum rule applied, and the party seeking to rely on that clause had it read against them. Whereas the second docket contract was unambiguous and clear.
Thank you for that, James. I suppose if we were to summarise the court's position on these exclusions, it seems that the court is taking a commercial reality view, if you like, on what the parties' respective risks were, rather than looking into necessarily the causes of things. As a general comment, could you make some sort of general comment on that?
Yeah. Look, my general comment is an endorsement and an agreement with that view. There's a real trend is the wrong word, but it's the first one that jumped into my head. There's a real approach from the bench to say that these clauses are not magical or special or different. These are commercial parties who are negotiating to allocate risk, and whatever risks they allocate one way or the other, so long as they do so unambiguously, they'll be held to that commercial arrangement. I agree with you, Jack.
Yep. So therefore, James, with the Arup decision, UK decision, do you think that's likely to be followed in Australia?
I'm going to say no, but only in a technical sense. So the comments made by Lord Justice Jackson are not a million miles away from the comments made in that sort of leading exclusion clause decision called Darlington. But I suppose what I'd go on to say is that I wouldn't like to rely directly on Arup as being precedent, but I would hold it out as a firm indication, perhaps a useful lens through which we can view exclusion clauses. And what I say is that a little passage from Lord Justice Jackson is not a million miles away from what we learned in Darlington about the nature of contra pref, generally speaking.
All right. Thanks, James. I suppose in finishing, there don't appear to be any further questions at our end. So, as indicated, I believe your presentation was clear and unambiguous, and I thank you. I thank you very much for presenting today, and wish you well. And I think we're going to move on to a break now. So thanks again,
Cheers.
James.
Thanks so much, Jack, and thanks so much for having me. Appreciate it. Cheers.
Thank you. Welcome back, everyone. I have our third speaker who's in our studio, Peter Seiss, and Peter will be giving a presentation on the unfair contract regime. Don't get caught out. His paper will cover key definitions of standard form contracts with consumers and small business. What is a consumer contract? What is a small business contract? What is it? When is the term unfair? When is the term not unfair? And he'll provide practical examples and solutions to these questions. A little bit about Peter. He's special counsel at Clayton Utz in Melbourne. He's an experienced commercial litigator with particular knowledge of trade practices law, insolvency and regulatory investigations. He believes litigation is about resolving conflicts so that a business can remain focused on what it does best, its business. Now, Peter writes regularly for peer-reviewed journals, including the Harper Review of Competition Law and Policy, and he's a strong communicator. He regularly speaks on legal topics, including the business on ABC TV. So I'll pass along to Peter now in the studio. Thank you. I don't know if I mentioned, sorry, just a reminder to delegates, if they can complete the survey, which can be found on the tab bottom, on the bottom of the screen. It may take a moment for the page to load. Peter, I think it's over to me. Thank you, Peter. Excellent presentation. I just want to remind everyone that delegates are encouraged to complete the survey about today's seminar, online seminar. Also, as Peter indicated, you're welcome to ask questions, and we've told you how you can do that so far. I'd probably start, Peter, with a question. I have an interest in, obviously, in commercial leasing and property, and I'm wondering, with regard to small business contracts, whether you can envisage any clauses either in land or leases where some clauses may be considered unfair.
I think the clauses which always catch the eye of people are ones that give one party the right to vary the price payable under the contract, so a right to vary rent, without some counterbalancing right to take part in the rent review process. That would be problematic. A right which allows the landlord or tenant to vary terms of the contract, that would be problematic, unless there was some countervailing right. But even the countervailing right to terminate the contract mightn't be enough, because terminating the lease could have significant consequences for someone who's running a business from the premises. So that right could be problematic.
With regard to land?
With regard to sale of land?
Yes.
Sale of land. aren't any particular cases that I've come across dealing with sale of land. So that's, even though it's specifically included, it's more being standard consumer transactions outside of that. So I can't think of anything off the top of my head for sale of land.
Okay. Peter, with regard to a guarantee, security provided by a tenant, where a landlord insists, if you like, take it or leave it, you must provide me with security of two properties, which goes over and above what is reasonably required. Is that something that could be attacked?
Potentially. It could be considered the main subject matter of the contract. So providing security might fall within that exclusion, and therefore it might not be actually capable of being attacked. Providing security, though, I think demanding security wouldn't be a problem. It's more the consequences of what will happen to that security if there's a breach of the contract. What are the parties' rights if there's a breach? Particularly if there is a breach, is a party given a fair opportunity to remedy that breach before it loses its security? Mm-hmm. I think that would be more of the issue than simply demanding security be provided.
Right. Thanks, Peter. I don't think that there are any further questions, unless I'm mistaken. No more questions? So I'd like to thank everyone. Well, there is a question? I'll scroll up. And I see. Okay. Adrian asks, I don't know where Adrian's from, but he says, in practice, how would you deal with what you deem to be an unfair contract term where the contracting party, being supplier under the contract, has provided an undertaking to the ACCC in relation to that exact term?
Right. So would the situation be that the party has provided an undertaking not to use that particular term because following an ACCC investigation, the ACCC and that party have agreed that the term is unfair?
I think that's the gist of the question. Yeah.
Well, I think I would simply draw the matter to the attention of the party and say that you're in breach of a court enforceable undertaking, and that's what an undertaking of the ACCC is. And I think that would be sufficient to persuade them to change the term or not enforce it. Also, it's a matter which you could raise with the ACCC, and I think the ACCC would then quite promptly take action against that party. So I think you wouldn't need to go down the path of starting a proceeding to persuade the party that the term is unfair, because that undertaking, pointing out that undertaking would be sufficient.
Could be relied on.
Yeah.
Okay. I can't see any further questions. So again, I want to thank Peter for his very concise and informative presentation. Thank everyone, the audience, for attending, and I thank all the speakers for attending today. It's been it's part of it's been done remotely, but we've certainly enjoyed it. So I'd like to close off here and thank everyone. Thank you very much.